Hey, ALSA UUM.
Hi, what can I help you with?
Do you know about the former Miss Malaysia, Pauline Chai's divorce case? Can you help me to find out this case?
Yes, the case name is Pauline Chai Siew Phin vs. Khoo Kay Peng, 2015.
What is this case mainly concerned with, and what actually happened in this case? Can you enlighten me with this?
Sure, no problem. For your knowledge, Pauline Chai, who is known as the wife, also the appellant in this case, has filed a divorce suit in the English High Court alleging that she had acquired an English domicile against the respondent, also known as the husband, namely Tan Sri Khoo Kay Peng, who stayed in Malaysia. The husband here, however, obtained an order from the Malaysian High Court with leave to issue a divorce petition. The wife sought to have the exemption extended, but her application was dismissed. According to the High Court ruling, the application failed to be granted as the wife's domicile was reliant on her husband, which was according to the English common law of domicile in family law. Hence, the husband could file his divorce petition in Malaysia, as the wife's domicile was dependent on his, and entitled the Malaysian court to have jurisdiction to entertain the petition.
Nonetheless, being dissatisfied with the decision held by the High Court, the wife had filed an appeal to the Court of Appeal, submitted that Section 48 of the Law Reform Act 1976 and the application of the English common law position on domicile is discriminatory of women.
Then, may I know what the court's decision is in this case?
Yes, sure. Eventually, the court in this case held that the husband was accordingly entitled the rights to file the divorce in Malaysian court, and therefore the Malaysian court also has the jurisdiction to hear the case. It is because, firstly, the husband's business was mainly in Malaysia, and it is also worth noting that the proceedings before the two courts were concerned with the division of properties and maintenance for the wife. Hence, there was no assertion argued by the wife that proceedings heard in Malaysia would be oppressive to her. Secondly, Malaysia's divorce laws in relation to domicile matter is still based on the English common law rules on the position of domicile, as well as the gist propounded under Section 48 of the Law Reform Act.
Wow, finally I understood what is happening in this case. I did agree with the decision addressed by the learned judge in this case, whereby in any event, any discriminatory effect of Section 48 of the Law Reform Act on the domicile of a wife or spouse will be the role of legislature to address, and not by way of judicial intervention, as in Malaysia, the domicile of a wife is followed by her husband's domicile based on the English common law of domicile. Thank you, ALSA UUM, for helping me out with the doubt.
You're most welcome.